Good evening everyone. My name is Roselle Mahinay and I am here to report about the Intellectual Property Code of the Philippines. First, the Intellectual Property Code of the Philippines is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions and for other purposes. We have here the State Policy Declaration. It states here in Republic Act 8293 that the state recognizes that an effective intellectual and industrial property system is vital to the development of domestic and creative activity, facilitates transfer of technology, attracts foreign investments, and ensure market access for products. Each shall protect and secure the exclusive rights of scientists, investors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such periods as provided in this Act. The use of intellectual property bears a social function. To this end, the state shall promote the diffusion of knowledge and information for the promotion of national development and progress of the common good. It is also the policy of the state to streamline administrative procedures of registering patents, trademarks, and copyright, to liberalize the registration and the transfer of technology, and to enhance the enforcement of intellectual property rights in the Philippines. We have here the second part of the law, which is law repealed. In RA 165, as amended, it is an act creating a patent office, prescribing its powers and duties, regulating the issuance of patents, and appropriating funds therefore. We also have here RA 166 or Republic Act 166. As amended, it is an act to provide for the registration and protection of trademarks, trade names, and service marks, defining an unfair competition and false marketing, and providing remedies against the same, and for other purposes as well. We also have here Presidential Decree number 49 and 285. As amended, it is a decree on the protection of intellectual property. We have here part 3 of the law, which is the parts of the law. Part 1 is Intellectual Property Office. Part 2 is the law on patents. Part 3, the law of trademarks, service marks, and trade names. Part 4, the law on copyright. And Part 5, final provisions. We have here Part 4, we have the government agencies. In Republic Act 8293, the agency of the government in charge of the implementation of the Intellectual Property Code is the Intellectual Property Office, which replaced the Bureau of Patents, Trademarks, and Technology Transfer. It is divided into 6 bureaus, namely, we have first Bureau of Patents. Bureau of Trademarks is the second one. Bureau of Legal Affairs. We also have Documentation Information Technology Transfer Bureau and Management Information System and EDP Bureau. And last, we have Administrative, Financial, and Personal Services Bureau. We have here the Part 5, which is the significant features of the law. In Republic Act 8293, a shift was made from the first to invent system under Republic Act 165, which is the old law, to first to file system under the new law. Whenever you are the inventor of that specific invention, you need to file it first. Who is the one who filed that one first is the owner of that specific invention. Okay, next, in the case of invention, the period of the grant was increased from 17 years from grant under the old law to 20 years from the date of filing under the new law. You will be granted by the intellectual property. In the old law, 17 years only, but now in the new law, it gives you a grant of 20 years. In the case of utility models, the previous grant of 5 years plus renewals of 5 years, each under the old law, was changed to 7 years without renewal under the new law. So instead of 5 years plus the renewal of 5 years, it is now 7 years. And it is without renewal. So you cannot renew that one. I mean, you can renew that one, but after 7 years. Under the old law, publication is made after the grant. Under the new law, publication is effected after 18 months. So we are done with this one. We have part 6, implementing rules and regulations. So we have here the word patents. What is a patent? So a patent is a right granted to an inventor by the federal government that permits the inventor to exclude others from making, selling, or using the invention for a period of time. So the patent system is designed to encourage inventions that are unique and useful to society. So like for example, with our innovations or the foods that we have innovated, so it needs to be patent first before we will, or before the public will recognize your work. It should be patent so that you will be granted by the government with the invention that you have. Why is patent important? So a patent is important because it can help safeguard your invention. So it can protect any product, design, or process that meets certain specifications according to its originality, practicality, suitability, and utility. In most cases, a patent can protect an invention for up to 20 years. So when you file for a patent, you will have the protection of your product or invented product for up to 20 years. So that means that when your work has been patented, no one will copy your product. We have here Rule 200, patentable inventions. So any technical solutions of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable shall be patentable in Section 21 of the Intellectual Property Code. So what can be patented? So anything that discoveries of materials or substances already existing in nature. Next, scientific theories or mathematical methods. Next, flora and fauna other than microorganisms and biological processes for the production of flora and fauna other than microbiological processes. We also have schemes, rules, or methods such as those for doing businesses, performing purely mental acts, or playing games. We also have the diagnostic and non-diagnostic methods of treatment for or practiced on humans or animals, but not products for use in such methods. So we have here in Rule 201 the statutory classes of patentable inventions. So a patentable invention may be or may relate to a product such as a machine, a device, or an article of manufacture, a composition. Or it could be of a matter or a microorganism. It could also be a process such as a method of use, a method of manufacturing, a non-biological processes, a microbiological processes as well. We also have here computer-related inventions and an improvement of any of the foregoing. So we have here Rule 203, which is a novelty. It is an invention that shall not be considered new if it forms part of a prior art. So it should be that your invention is on your own and not from the other inventions. It is also stated in the Section 23 of the Intellectual Property Code. So we have here the rule 204. So 204 is equivalence, and a strict identity test is required to be applied in assessing novelty. So a single prior art reference must disclose each and every element of a claim invention in order to destroy novelty. Equivalents are considered only in assessing invented steps. So we also have here rule 205, which is also known non-prejudicial disclosure. So a disclosure of information contained in application during the 12 months preceding the filing date or the prior date of an application shall not prejudice the applicant on the ground of lack of novelty if such disclosure was made by the inventor, a patent office, or a third party. We have here rule 206, 206 inventive step. So an invention involves an inventive step if, having regard to the prior art, it is not obvious to a person skilled in the art at the time of the filing date or priority date of the application claiming the invention. So it also should be only prior art made available to the public before the filing date or priority date shall be considered in assessing invented step. So we also have here rule 207. So a person having ordinary skills in the art. So the person having ordinary skills in the art is presumed to be an ordinary practitioner, aware of what is common, general knowledge in the art of the relevant date. We also have here rule 208, industrial applicability. So an invention that can be produced and used in any industry shall be industrially applicable. It is also written in section 27 in IP code. We have here the application. So in rule 500, who may apply for a patent? So it should be any person, natural or juridical, may apply for a patent. If the applicant is not the inventor, the office shall require him to submit a proof of his authority to apply for the patent. So like for example, if you have an inventions right now, and we are now having our master's degree in Main campus, so that means that Main campus will apply for the patent in behalf or on behalf of the person that or the inventor of that specific product. But Bohol Island State University will recognize the inventor of that specific product. So your name will be written on the application for patent as well as the name of Bohol Island State University main campus. So in Rule 501, when the applicant dies, becomes insane or incapacitated. In case the applicant dies, became insane or incapacitated, the legally appointed administrator, executor, guardian, conservator, or representative of the applicant may sign the application paper and other documents. He may also apply for the obtain the patent in the name of the applicant, his heirs or assignee. So this one in Rule 501, so like for example for that is the owner of the Coke or the one that knows the recipe of Coca-Cola. So they are not encouraged to be on the same plane when they travel. Why? Because there should be a successor or there should be a person who knows the recipe of the Coca-Cola. So that's their technique as well or tactic as well, that in order for them to have the success of their product, they need to secure the recipe of the Coca-Cola products. So we have here Rule 502, assigned invention and patents. So in case the whole interest in invention is assigned, the application may be filed by or in the name of the assignee who may assign the application. So, in case of an eloquent portion or undivided interest, any of the joint owners shall sign the application. So we have here, next one is the process of acquiring a patent. So in Rule 400 of patent application, an application for a patent shall be in writing. It may be written in Filipino or English and shall be filed by post or directly with the Bureau. We also have here Rule 401, the payment of fees. So an application shall be subject to full payment on the filing fee, the search fee, and the publication fee within 1 month after the filing date of the application. So that's why Ma'am Donna said that if you will acquire for a patent, you don't need to pay it full, or you don't need to have the full payment of it. You need to at least wait for 1 month after the filing so that you will have to pay for the publication fee and any fees that is required for the acquiring of patent. So we have here Rule 404, the request. So the request shall contain the following. We have the petition of the grant of patent and application's name and address. We also have here Rule 401, the title of the invention. So the title of the invention shall be as short and specific as possible. So it should be that you have your name there indicated or the name of the product that you have invented. So we have here the grant of a patent. So a grant of patent in Rule 1000, it is if the application meets the requirements of the IP code and these regulations, or the office shall grant the patent, provided that all the fees are paid on time. If the fee requires fees for grant and printing are not paid in due time, the application shall be deemed withdrawn. We also have here Rule 1001, the contents of the patent. So the patent shall be issued in the name of the Republic of the Philippines under the seal of the office. Shall be signed by the Director of Patents and registered together with the description, claims, and drawing, if any, in books, the records of the office. So Rule 1002, publication upon grant of patent. So the grant of patent together with other information shall be published within 6 months. We also have here Rule 1003, and any interest party may inspect the complete description, claims, drawings of the patents on file with the office. Rule 1004, the terms of patents. So the term shall be 20 years from the filing date of the application. However, a patent shall cease to be in the force and effect if any prescribed annual fees therefore is not paid within the prescribed time of the patent and cancelled in accordance with the provision of the IP code and these regulations. We have here the trademarks. So trademark is very important because it refers to the recognizable insignia, phrase, word, or symbol that denotes a specific product and legally differentiates it from all the other products of a kind. Like for example, I will be making my own product or my own establishment, and the name of my establishment is Roselle Donald's or Rose Donald's. So there is a possibility that I will be sued by McDonald's. Why? Because I am using the Donald's or the same sounds as what they have. So that is trademark. So you need to have your specific logo, your specific trademark, your specific symbol, or your specific word for that specific establishment that you will make. So why is trademark very important? So while it's not required by law, it's a good idea to register the name of your business as a trademark. Why? Because of the trademark, people will know on what is your foods or services that is being offered to them. Or a person shall know where to go if they know what is the specific name or trademark of your establishment. So we have here trademark infringement. So as I've said, it is the unauthorized use in commerce of a registered trademark or copy or colorable imitation therefore or thereof, which results in the likelihood of confusion among the consuming public. So it should not be practiced. It's a big no-no because there is an administrative fines ranging from 5,000 to 150,000 pesos and additional fine up to 1,000 for each day of continuing